The XRP Army is awaiting Judge Torres's decision on several motions, including the ultimate finding in the remedies phase. In the ongoing legal dispute between Ripple Labs and the U.S. Securities and Exchange Commission, according to an attorney, following a settlement between the U.S. SEC and Terra, the Ripple or Coinbase case will be the first to be heard by the Second Circuit Court of Appeals to determine the legal status of cryptocurrency assets. The case will be moved to Second Circuit Court of Appeals due to SE settlement. In an article on X, well-known pro-crypto attorney James Murphy, also known as Metal Mom, stated that the settlement reached between the defendants Key One and Terraform Labs in the U.S. Securities and Exchange Commission is a positive development. The SEC is suing Do Kwon and Terra separately for millions of dollars in fines. According to Metalman, the CC settlement may cause Coinbase or Ripple, who have already filed for an interlocutory appeal, to bring the case before the Court of Appeals for the Second Circuit. The legal standing of digital assets will be resolved according to the leaders of the industry. Notably, the U.S. Court of Appeals for the Second Circuit already decided in Coinbase's favor in a lawsuit holding that cryptocurrency secondary market transactions do not qualify as securities. The federal judge's ruling also established a significant precedent, which barred the U.S. SEC from appealing the CV Ripple Labs case's XRP secondary market sales ruling, withholding important information to pressure the SEC for more records. Empower Oversight has submitted a fresh FOIA request. The watchdog is mainly looking for documents related to the former SEC Chair Jay Clayton and Director William Hyman's assertion that several cryptocurrencies, including Bitcoin and Ether, are not securities. Given that the claims in the Ripple v. action are similar, this could have a big effect on that case. President of Empower Oversight Tristan Levitt stated, "The SEC's no relevant records responses seem incredibly suspicious. We've asked each member of his staff for any pertinent documents. We plan to track down any further methods Clayton may have tried to utilize for his crypto communications. In the last day, the price of XRP has increased by almost 2, and it is presently trading at 5,269 cents. 5,188 cents is the 24-hour low, and 5,307 cents is the 24-hour high. In addition, a boost in trader interest is indicated by the 31 increase in trading volume over the previous day. According to CoinGlass, when traders move to buy XRP, derivatives data also flashes a buy signal. Due to significant purchases on Binance, Bitget, Kraken, and Coinbase, the total open interest in XRP futures increased by more than 6 in the last day, surpassing 1.25 billion. In the meantime, Brad Garlinghouse, CEO of Ripple, reiterates that an XRP EF is coming and projects the launch of a spot ETH that will track real-time XRP pricing by 2025. According to Brad Garlinghouse, CEO of Ripple, the company's legal battle with the SEC might be resolved by summer, possibly with a multi-million-dollar punishment. Garlinghouse highlights the need for precise regulations and suggests that XRP will be the first digital asset in the U.S. to be completely regulated. Ripple's resolve to refute the SEC's accusations in spite of formidable legal obstacles highlights the company's commitment to regulatory compliance and has wider ramifications for the cryptocurrency ecosystem. In anticipation of a historic final court battle with the U.S. Securities and Exchange Commission SEC, Ripple is getting ready. Brad Garlinghouse, the CEO of Ripple, has publicly voiced his optimism over the resolution of Ripple's legal battle with the SEC. According to Brad Garlinghouse, the matter will conclude this summer with the payment of a fine that is in the millions, not the billions. In the US, XRP would be the first digital asset to be fully regulated if the penalties are in millions rather than billions, as Garlinghouse believes. The case may end in favor of Ripple and XRP. By this summer, he thinks the case might be resolved. Garlinghouse's comment that XRP might be the first completely regulated digital asset in the US highlights the significance of clear regulations in the cryptocurrency market. XRP's ability to gain broader acceptance and be incorporated into current financial systems hinges on how clearly defined its regulatory framework is once this legal process is concluded. Allegations made by the SEC in December 2020 claim that Ripple was selling XRP tokens through unregistered securities offerings. Unlike many of its rivals, Ripple decided to dispute these accusations. Garlinghouse called the SEC's actions embarrassing in a recent CNBC interview and reiterated Ripple's belief in the case's factual and legal merits. Despite some significant legal obstacles, Ripple has the backing of several stakeholders, including major industry participants like Coinbase. Ripple's steadfast resolve to refute the SEC's allegations highlights the significance of the wider ramifications for the cryptocurrency ecosystem, as well as its commitment to regulatory compliance. The outcome of the judge's ruling, which may mark a sea change in cryptocurrency legislation, is anxiously anticipated by the cryptocurrency world as the legal struggle draws to a close. May's manufacturing PMI dropped from 49.2 to 48.7, boosting speculation for a September Fed rate reduction. The favorable session was further enhanced by the expectation of a Republican Party triumph, with cryptocurrency companies contributing to help us senators on Capitol Hill who are pro-crypto. Coinbase Coin, which has previously received contributions from Andreessen Horowitz and Ripple, gave $25 into Fairshake on Monday. The donation was revealed on Coinbase's corporate blog. On its website, Fairshake PAC states that they back us politicians who are determined to keep the U.S. the place where innovators creating the next wave of the internet are born. The Coinbase blog covered us politics, including the presidential, Senate, and House contests. Coinbase, in particular, emphasized the importance of the U.S. presidential election by stating, the president appoints important members of his administration, Treasury Secretary, the chair of the SEC, etc., and has the power to veto laws, so the race for president is also important. Plus, President Joe Biden stirred things up on Capitol Hill and in the cryptocurrency sector last week when he vetoed the SABE 121 resolution. A U.S. administration that is supportive of cryptocurrencies might drastically change the U.S. cryptocurrency scene by enacting laws that safeguard consumers while promoting innovation. Another possibility that could lead to an XRP spot ETF market is a new SE chair. CVD awaiting court decisions and the reconsideration buyer demand for XRP was unaffected by any changes about WSECV's Ripple lawsuit. The outcome of the SECV's Ripple case continues to be the main focus while investors await the court's decision on the Ripple motion to seal. In April, Ripple argued against the SEC's demand for an over $2 billion disgorgement, arguing instead for a $10 million fine for breaking securities rules. The SEC also made arguments to the courts in March to have Ripple barred from selling XRP to institutional investors through an injunction. Whether the court finds that Ripple continued to violate securities laws following the December 2020 complaint could determine whether or not to grant an injunction. In defense of its post-complaint sales, Ripple claimed that XRP sales were made through ODL contracts to approved or institutional investors. ODL agreements, as Ripple pointed out, stop losses or profits. Even though ODL agreements might be viewed by the courts as investment contracts, Howey may strike the investment element of the agreement due to the prevention of profit or loss. The possibility of the SEC filing an appeal against the programmatic sales of XRP rule remains, even while Ripple awaits a decision in the summer. The SEC filed a motion for interlocutory overturn in August 2023 in an attempt to overturn the court's decision. But in October 2023, Judge Annalisa Torres denied the SEC's motion for an interlocutory appeal. Thus, the SEC was forced to wait until the Ripple case was resolved.